It is an honor to be part of this webinar series, and I'm really impressed with everything that have been said in the introduction, and thank you very much for your kind introduction of me. So let me share the screen now. Right, can you see my screen now?
Yes, ma'am.
Yes, wonderful. So today we will be talking about improving access to medicines during the COVID-19 pandemic, and I will talk about some international approaches on how to do that, right? So we have been living for more than a year and a half in a global pandemic, and all WTO members are making tremendous efforts to contain the spread of the pandemic and provide medical care to those who are ill. And of course, an effective response to the pandemic requires quick access to affordable medical products. As you know, the pandemic has led to a rapid increase in global demand for such products, and many countries facing acute drug shortages, limiting their ability to effectively respond to the pandemic. And shortages of these products has endangered hundreds of thousands of lives and resulted in many preventable deaths. It also threatens to prolong the COVID-19 pandemic, and we know the virus is mutating and spreading rapidly, and the longer the current crisis lasts, the greater the social economic impact will be. So this makes international cooperation necessary and urgent to quickly contain the virus. And as new diagnostics, treatments, vaccines for COVID-19 are being developed at the moment, and there are serious concerns about whether they will be available soon, and whether they will be available in sufficient quantities and at affordable price to meet global demand. And at the international level, the question of the role of intellectual property rights and access to COVID medical products is being discussed, and whether such rights are an obstacle to the timely provision of an affordable medical products to patients. And we will talk today about various mechanisms discussed at the WTO, which are aimed at increasing the production of vaccines and medicines. But before we go into details on these specific issues, I think that it is important to set the background and important to understand all the proposals that we'll be discussing today. So we will talk about first about patents. What is a patent? What is the pharma industry, and the importance of patents to pharma companies? So what is a patent? Patents are granted by the state for the protection of new inventions. And you can get a patent for a process or product. And such inventions must meet certain patentability requirement, right? Not everything can be patented. Only inventions that are new, that have inventive step, meaning something that is not obvious for the expert in the pharmaceutical field, for example, if the invention is medicine, and must be capable of industrial applicability. Patents last for 20 years from the date of patent application, and what is important for today's discussion, they give the patentee the exclusive right over the invention, meaning that only the patentee can use the invention, no one else, and if others want to use it, then they must ask for permission, and patentee is free to give such permission or refuse. And patents are sometimes viewed as a social contract between the inventor and society. And this means that in return for patent protection, the patentee must make the invention public. So this sort of induces the disclosure of invention in exchange for limited monopoly protection. And this disclosure is the important function of patent law. Otherwise, many important inventions would be kept secret, and we wouldn't know about these inventions. We would not know how they work and would not be able to study them. So in a sense, this generates the technological advancement. And importantly, patents are often viewed as an instrument to encourage innovation. And this is something that is argued by the pharmaceutical industry also, because by providing this limited exclusivity or monopoly on the market, they allow the patentee to recoup investments, sometimes very significant investments into research and development, and allow to gain some profit. So why are patents important? And a good example is the pharmaceutical industry. It is a very unique industry, unique in its complexity. It is characterized by heavy state regulation, sometimes by competing interests of the pharma business and society, and it involves multiple actors. And in these complex relationships, two crucial actors are there. Is on the one hand, originators play an important role in developing new and improved medicines, right, for the benefit of society. On the other hand, generic companies benefit society by supplying cheaper equivalents of the originators' medicines, and this leads to the reduction of drug prices and facilitate access to affordable medicines. And these two elements of the pharmaceutical industry are constantly interacting and have a very significant impact on each other. And in the pharmaceutical industry, innovation is its backbone, and originators play an important role. The process of drug development is long and complicated, requires significant investments, and bears considerable commercial risks. Industry claims that only 1 out of 10,000 compounds synthesized in laboratories will eventually reach the market. It also very expensive and a long process. It takes 10-15 years to develop a drug, and it costs industry says $2.5 billion. And it is, as I mentioned, very heavily regulated. So in order to sell a drug, you need to obtain marketing authorization. And for this, you need to prove that your drug is safe and effective. To do this, you need to conduct clinical trials, which are also lengthy and expensive. So you could see that lots of significant efforts and investments are involved. And of course, pharma companies want to protect these investments. So for these, they rely heavily on exclusivity granted by intellectual property rights and in particular patents. And as I mentioned, patents provide a 20-year monopoly right during which a pharmaceutical company enjoys market exclusivity and is able to charge monopoly price for its products. And originators argue that they need strong patent protection. It is essential because they need to recoup their investments, and this will incentivize them to engage in further innovation. And a good example of the effect of patent protection is a drug called Sovaldi, and this is a treatment for hepatitis C. And it's a very important treatment because in 2015, World Health Organization estimated that more than 70 million people were infected with this disease in the world, and most of them live in poor countries. And the earlier treatment for this disease was very toxic and had some very nasty side effects. And Gilead introduced an innovative drug, Sovaldi, with active ingredient sofosbuvir. And this is now used in the treatment of hepatitis C. And this new generation of medicines offers significant gains in efficacy and much fewer side effects. And it is the first treatment to achieve cure rates over 90%. So it's a very good drug. And the only problem with this drug is that it is very expensive. The drug was initially charged by the company at a prohibitive price of $1,000 per pill, or $84,000 for a 12-week treatment in the US. And just in the first quarter of 2014, when the drug was launched, the company's profit was over $2 billion. So obviously, one of the main reasons for such high pricing of this life-saving medicine was because the company enjoyed the monopoly on the market provided by the patent protection and market exclusivity. Once such patent protection expires, other companies may develop generics of a branded drug and start competing with originators for the market. And this is called generic competition. And generic drugs are bioequivalent versions of a branded drug that has lost patent protection. And generic entry typically leads to a significant market share loss by originator and around 20-30% reduction in price. And sometimes it might lead up to 90% price reduction. So generic competition is very important. A very good example of this, of the effect of generic competition on originators' drug prices, is Eli Lilly's blockbuster antidepressant Prozac. In late 1980s, Eli Lilly began to market Prozac, which essentially revolutionized the treatment of depression. And it quickly became the biggest selling drug in the history of pharmaceutical industry at that time. But in 2001, when a patent protecting this drug expired, Eli Lilly lost 70% of its market share and more than $2 billion in annual sales in the US. So this shows the importance of patents in the pharmaceutical industry and their effect on the market, both during their life, this leads to high prices, right? And when they expire, more affordable medicines. So this is the system that we know today. But this system of medical innovation and access to medicines, a proprietary system of pharmaceutical innovation, has taken shape fairly recently. And in the past, many countries didn't provide patent protection in medicines, or provided only limited protection, for example, only to process of their manufacture, but not to the product itself. And therefore, countries were free to develop their national IP-related policies to combat high prices and facilitate access to medicines in accordance to their local needs. And the lack of patent protection for medicines was justified by the risk of high prices on a patented drug that would affect the accessibility of affordable treatment. And up until 1995, drugs remained unprotected by patents in approximately 50 countries. For example, India and Brazil are among these countries. But this changed in 1995 when the WTO agreement on trade-related aspects of IP rights, the so-called TRIPS agreement, came into force. And the signing of this agreement became a grand victory of the big pharma. This was because they wanted strong protection for their pharmaceutical products worldwide. But before that time, as I mentioned, some countries did not provide such protection, and that meant that on their territories, local companies were able to freely copy their products and start manufacturing and selling. And the most famous example is, of course, India, in which essentially this lack of protection boosted the development of a very powerful generic pharmaceutical industry, and it still remains the pharmacy of the world. So obviously, international pharma companies were not happy about the state of protection and heavily lobbied the high level of patent protection in all WTO member states. And the TRIPS agreement came into force in 1995.
Ma'am, your mic has been muted. Could you please?
This is interesting. Was it muted for the last 10 minutes when I was speaking?
No, ma'am. It was all about 2 to 3 seconds.
Seconds,
sorry.
that's all, man. Yeah.
Sorry. Okay, thank you for telling me this. So, right, so where was I? So that when TRIPS agreement came into force in 1995, it finally set the so-called minimum level of protection. This brought this minimum level of protection to an international level. And everyone had to have at least this minimum level of protection. Everyone, meaning all the WTO member states, had to provide this minimum level of protection or higher, but not less what is required in the TRIPS agreement. Otherwise, the country would violate their obligations under the TRIPS agreement and could face serious repercussions. And the changes in this area were brought by the wording of Article 27 TRIPS, which establishes the rules on patentable subject matter and provides that patents shall be available for any inventions, whether products or processes, in all fields of technology, provided that they are new, involve inventive step and capable of industrial application. So these words, all fields of technology, essentially changed everything, right? So such a mandatory minimum standard resulted in the protection extended to all inventions, including pharmaceuticals. And therefore, as a result of this international agreement, every member state undertook an obligation to introduce patent protection for drugs in their national legislations. And these new global rules, coupled with bilateral treaties between countries, especially between developing countries and developed countries, and also that this bilateral treaties strengthen the protection even further, the so-called TRIPS Plus provisions, and some patent-related strategies by pharmaceutical companies directed at evergreening their market monopoly. So all this taken together resulted in many countries not being able to provide sufficient access to essential medicines for their population. And such changes were particularly detrimental to developing countries that could not afford the burden of pharmaceutical patents. They were simply lacking the necessary financial resources in order to bear the cost of expensive patented medicines. And for example, India that didn't provide patent protection for medicines before TRIPS could no longer reverse engineer patented foreign medicines and sell them at low prices in developing countries. So as was stated in the report prepared by the UN High-Level Panel on Access to Medicines in 2016, diseases such as HIV, which have become manageable chronic conditions in developed countries, continue to kill millions of people in low and middle income countries because of the unaffordably high prices of patented medicines. But also developed countries are increasingly suffering from high drug prices, which put significant pressure on national healthcare budgets and force governments to reconsider their policies in this field. Right, so this background is important to understand in light of the current pandemic and the insufficient supply of vaccines and medicines, which has proven to be a serious challenge for many countries. As you know, it is estimated that around 11 billion doses are required to vaccinate 70% of the world's population. And most of the vaccines manufactured today have been acquired in excess by wealthy countries. So, for example, Canada has purchased enough vaccines to inoculate its population 5 times over. And at the same time, poor countries are lagging significantly behind. And it is estimated that it may take several years for people in the lowest income groups to be vaccinated. So this has raised a crucial question: how can the production of COVID-19 vaccines be accelerated and their equitable and affordable worldwide distribution ensured? And one of the key issues here is whether IP will become a barrier to the rapid production of COVID-19 vaccines and their equitable distribution worldwide. We know that pharma companies are engaging in proprietary research and generating their proprietary data, and the outcomes of this would be and are already patented and protected by other types of IP. So, for example, Moderna, one of the producers of mRNA-based vaccine for COVID, is reported to hold over 270 issued or allowed US and foreign patents protecting mRNA-based technology, with over 600 worldwide pending patent applications. And the company has identified at least 7 granted US patents that it alleges protect its vaccine. And yes, Moderna has pledged not to enforce its patents while the pandemic continues, but it is unclear when it will consider that the pandemic is over. So to date, several solutions have been proposed to address the problem of access and increase production of anti-COVID medicines and vaccines. And the key proposals are voluntary technology transfer, compulsory licensing, and IP waiver. I'll touch upon briefly each of them now. So understanding the limitations of the current vaccine development and manufacturing mechanisms, numerous calls for sharing vaccine technologies in order to boost their production have been made. And this includes the World Health Organization COVID-19 Technology Access Pool, the so-called CTAP, and that has called on the global community and, most importantly, pharmaceutical companies to voluntarily share their knowledge, intellectual property, data that are necessary to defeat the virus. And while this technology pool has the potential to accelerate the production of vaccines, it has attracted no contribution since it was established in May 2020, because pharmaceutical companies have refused to share their vaccine technologies with them. and they want to retain full control of their vaccine technologies, and they are, focused on scaling up their own manufacturing capacities and striking deals with other companies to produce their vaccines. But since the pandemic has a global dimension and billions of vaccines are required to be manufactured and distributed worldwide, and importantly, in an accelerated speed, in order to contain this rapid spread and mutation of the virus across the globe, the current setup of vaccine production is undoubtedly insufficient to protect the world's population against the pandemic. So another mechanism is to utilize currently available flexibilities in the TRIPS agreement in the form of compulsory licensing. And so what is a compulsory license? It is a permission granted by a state authority that authorizes the licensee to use a patented invention without the patent holder consent. And it was confirmed in 2001 by the Doha Declaration that compulsory licensing is one of the flexibilities under the TRIPS agreement, and that all WTO members have the right to grant such licenses if necessary. And this mechanism has been implemented in majority of jurisdictions worldwide and also may be relied upon to address public health problems if necessary. It was used relatively rarely before the pandemic and mostly by the developing countries. And this was because they were afraid the retaliation from the developed countries. But it attracted close attention during the pandemic. And some countries have already granted compulsory licenses for using medicines against COVID-19. For example, Russia and Hungary granted compulsory license for remdesivir. Also, Israel granted a compulsory license for Kaletra, the HIV drug. At that time, it was considered that it was it could be used in treatment. Interestingly enough, after this move, AbbVie, the proprietor of a patent related to drug Kaletra, announced that they will not enforce their patents worldwide in relation to COVID-19, but also in relation to other indications. Also, other countries have been also amending their national legislation to make this mechanism more effective and to ensure that compulsory licensing is granted swiftly if necessary. And these countries include Canada, Australia, Chile, Germany, Hungary, Russia. So the use of this mechanism is supported by the European Union. It is in its submission to the WTO TRIPS Council, it suggested to clarify the compulsory licensing mechanism. They said that all WTO members should be ready to agree on the following. First, the pandemic is a circumstance of national emergency, and therefore the requirement to negotiate the right holder may be waived. Well, note that this is already there in the TRIPS agreement, so it's unclear what is new here. To support manufacturers ready to produce vaccines or therapeutics at affordable prices, especially for low and middle income countries on the basis of compulsory licenses, the remuneration for patent holders should reflect such affordable prices. Again, it is not very clear why it is here and what needs to be clarified, because the topic of remuneration has been discussed a lot, and World Health Organization published a guidance on how to calculate the fees, so nothing new as well. And the last, that the compulsory license could cover any export designed to countries that lack manufacturing capacities, including via COVAX facility. Again, this is something that is possible by the current provision. So Article 31b. So again, it's not very clear what is needed here to be clarified. So this proposal is considered weak, bringing no significant changes to the current system, and the scale and dimension of the current pandemic pose certain limitations on the effective utilization of this mechanism, and this have not been addressed in the proposal. So it is hardly capable of substantially improving this mechanism in order to boost the production of vaccines. So the last thing I want to mention now is another proposal that was advanced by South Africa and India to temporarily waive the IP rights in the TRIPS agreement. And the main points are to waive IP rights, and this includes copyrights, design, patents, and undisclosed information. It is suggested that the waiver will have a duration for 3 years, and it relates to health products and technologies, including diagnostics, therapeutics, vaccines, medical devices, personal protective equipment, and so on, to prevent treatment, for the prevention, treatment, and containment of COVID-19. So essentially, what the IP waiver means at the WTO level, if the waiver is agreed upon, WTO members would not be able to sue another WTO member for TRIPS non-compliance in case where it waives IP rights at a national level. And the effect of the IP waiver at a national level, in turn, is that by implementing the IP waiver, IP rights would not be enforceable against third parties. So other manufacturers will be able to start manufacturing medicines and vaccines without fear of infringing any IP rights. And this proposal has generated a massive support, including by the US, but US support is limited to vaccines only. Right, so this has raised heated debates as to the effectiveness of either of these proposals to ensure the rapid production and distribution of vaccines, and which of these paths should be taken by the global community to finally stop the pandemic. While each of these proposals may help to improve the production of COVID vaccines to various degrees, they both have some strengths and weaknesses and may not be sufficient to ensure the effective, speedy increase in vaccine production, to my opinion. But I think that IP waiver is probably a better option that we have today. So, what do you think? I will leave you with this question, this open question: which of these proposals would be more effective in facilitating the production of COVID-19 vaccines? Happy to discuss this with you after the presentations. Thank you very much for your attention.
For inviting me for this session on the topic compulsory license under Indian patent system challenges and issues. So before going into the theme of this today's topic, I would like to discuss a few things regarding to the patent, and also why exactly the compulsory license is required, and what are the grounds that are required for the compulsory license, mostly with related to Indian jurisdiction, and also are there any challenges with related to the compulsory licensing in India mainly. So as we know that, with reference to our previous session as well, the intellectual property rights are territorial in nature. So as we know, like there are different intellectual property rights, and I'm not going to touch each and every intellectual property rights in this session. So as based on the threshold of the intellectual abilities, the intellectual properties are categorized into different categories. So among them, for the innovations, patents are one of the best solutions to protect their intellectual property rights. So as the patents or all the intellectual property rights are territorial in nature, so what exactly does this mean is that, okay, when you protect your intellectual property right in India, so you are having rights on that intellectual property in that particular jurisdiction only, right? And also to protect your intellectual property, right, mainly with related to patents, as we are going to discuss on the patents here. So we need to look into the patentable subject matter with related to that particular jurisdictions, which should be complied with this TRIPS agreement, as we discussed already in the previous session. So in India, actually, so the patents are granted for inventions. So when you look into the Patent Act 1970 in India, which guards in patent right protections and also with related to the rights confined to the intellectual properties and also enforcement of patent rights in India. So as per the Patent Act in India, so when you look into the section 2M, so which says that, okay, the patent is for the inventions under this act, that's it. So when you look into Indian Patent Act, so patents are granted to the inventions. That invention should be defined as an inventions under the Patent Act, Indian Patent Act 1970. Now, what are the inventions that can be get granted as a patent in India? So in India, for any product or also for the process, they should have an inventive step and also industrial applicability to qualify as a patented application. So the process or as the product should be always novel. It should be always new in nature. So it should not exist elsewhere in the world. So it should be completely new technology or else new process, which is having inventive step as well as the industrial applicability. So with related to the inventive step within Indian patent system, so it should have technical advancements or else economic significance, or else it should have both, right? So these are the patentable subject matter in India actually. So along with this, if any inventions or else any innovations, for example, let's take it any pharmaceutical product or also process. As we know that in India now, even the product is also pharmaceutical product is also protected as a patent in India after TRIPS obligations. So apart from that, Section 3 is there in India. So Section 3 says that, okay, even though these are the inventions, but these are not inventions as per the Patent Act in India. So there are 15 subsections under Section 3. So which says that, okay, this A to P. So Section 3A to 3P. So these are the subsections which consist of different inventions, but these are not a patentable subject matter in India. Like, for example, an inventions which are contrary to the public order and morality, or else a part of a plant or as a part of an animal. So if you want to protect as a patent, so this cannot be patentable subject matter. A business method or else computer program per se. So these are the few inventions, even though these can be qualified as an inventions, but these are not a patentable subject matter in India. So to get a patent in India, so these are the important criteria that should be maintained. Yes. So now let's take it that we have qualified all the patentable subject matter criteria, and then our invention or else our patent or article or a product is eligible to get a patent, and we have filed for a patent, and there are different prosecution stages. And now we got a patent for our particular product or process. Now, what are the rights of that patent is? So this is dealt in Indian Patent Act. So when you look into the Indian Patent Act, there are few rights that are confined to the patentees. So what are their rights? So these rights are actually negative in nature. So these rights always prevent a third party from making of that particular patented invention, or else for using of that particular patented inventions, or else preventing offering for sale, and also preventing selling of that particular patented inventions. So if there is a consent with the patentees, yes, they can do that. So the consent can be in the form of written agreements or else licenses or else cross licenses, or else there can be different grounds. So what are the different grounds that can be like without consent also? Can they make this particular patented article making, or else they can use this particular patented article in India or not? This also we can look in coming slides. So the basic thumb rule is that, so without the consent of the patentee, so no one can make that particular patented inventions, or they cannot use that particular patented inventions, or else they cannot offer for sale of that particular inventions, or also they cannot sell that particular patented inventions. So how long this can be happened? So how long these rights are there? These rights in India, it is for 20 years. So from the date of grant of that particular patent, So till 20 years, that patent is having that particular monopoly right on that. So if that particular patentee wishes, or else if he thinks that after like 5 years or 6 years, he would like to give a license to particular company, or else particular any other particular pharmaceutical product company which is having good manufacturing facilities to produce that particular patent, so he can give that, he can give that particular warranty license for any particular time period, and hence with his consent this process is happening, so it is not an infringing of that particular patent right. So 20 years, the patentee is having that particular rights. Now, whether these 20 years, can this patentee can enjoy this monopolistic rights that are given under Section 48 of Indian Patent Act or not, is one of the interesting question. So when you will look into the Section 48, it clearly says that it prevents any third party by doing this above activities without his consent. But when you keep on going and look into that or intellectual or patent act, so there are few sections, or else there are few mechanisms where even though without the consent of that particular patentee, you can start using that particular patented inventions. So what are they? So without the authorization of right holders also, there are few things that a person interested can do, but before doing that, or else before using that particular patented invention, or else any particular patented article, so they need to obtain that particular process, so which is known as a compulsory licensing. So when you look into the compulsory license, even though the patentee is not interested, okay, to give that particular license to him, so there is a mechanism called as compulsory license, where any interested person can approach the controller. So in India, I'm talking about the Indian scenario here. So they can approach the controller of patents to issue of that particular compulsory license to him or her. So any interested person. So it is, so if any, let's take it, any pharmaceutical product are there, which is related with the COVID treatment. Now, any interested person or as any interested company, so if they wish to obtain that particular compulsory license in India, they will approach the controller of patents, right? So what are the exact grounds that they need to mention, whether each and everyone who are interested can go and apply for the compulsory licensing, or else are there any criteria for that particular obtaining of that particular compulsory licensing, is what is very important, and then that's what we are going to discuss in our coming slides. So there are two other interesting things. So with related to the TRIPS agreement, and also like if you look into the Indian Patent Act, so there is for the natural emergency and also extreme urgencies. So mainly with related to the COVID-19. So this is the best example that we can give here now. So in such cases also, the government can have this license, compulsory license on that particular patented invention, even though a person is enjoying that monopolistic right. So the government can approach that controller of patents in that particular jurisdiction. So it all depends upon that particular territories or else the states where the patent office is located, and then the process will be followed. So in India, we need to approach the control of patents to have or else to request for the compulsory license. Now, when you look into Indian Patent Act, so there are few grounds that are mentioned for the compulsory licensing, and also there are few time frames that are mentioned to obtain a compulsory license. So first and foremost thing is that at any point of time, and any interested person can approach, but the time should be after the expiry of 3 years from the date of grant of that particular patent. Why? So the 3 years at least we should give to that particular patentee to develop or else to market his particular product and to make it available to the public throughout that particular territory. So at least there should be a 3 years of time. So once after the expiry of that particular 3 years of time, so any interested person can make an application to the controller for the issuing of a compulsory license, right? So there are three important grounds that are mentioned under Indian Patent Act for obtaining a compulsory licensing or else for approaching any compulsory license in India. So first and foremost thing is that, okay, that the reasonable requirements of the public has not been satisfied with that particular patented inventions. So the main particular intended purpose of that patented product, let's take it pharmaceutical products, okay, if it is going to target any disease, like a cancer or else HIV or else with related to the COVID. So that reasonable requirements of that particular public is not been satisfied with related to that patented application. So after 3 years, okay, at least 3 years time we should give. So if this is the one ground, so any interested party can approach for compulsory license. Or a patented invention is not available in affordable prices to the public actually. So the price of that particular patented article is very much more. So the public couldn't able to afford that particular patented product. As we know that, so 20 years of time is their monopolistic time where a product can be sold at any number of that particular price actually. So that number can be tagged. So for that particular, it can be like, for example, a strip of the tablets can be 20,000 or etc. There is a good example with related to the compulsory license in India. So there is only one compulsory license till date granted in India. So way back. So in that, what are the grounds that they have mentioned, and also what are the rates or else royalty rates that they have mentioned, we can discuss with related to that affordability of that particular price. And also the most important or with related to the patented invention is nowhere available in that particular territory in India actually. So there are like, so either of any ground, it doesn't mean that, okay, it should satisfy all these three grounds to apply or to request for any compulsory license from any interested party. So it can be either ground A, ground B, or ground C. Any of the above grounds, any interested person can approach the control of patents to get a grant of compulsory license. So the compulsory license is that, okay, without the consent or without the interest of that particular patent holder, so you are requesting and you are pressurizing him or her to grant that particular compulsory license for a specific time period to make or else to produce that particular products. Yeah. So now in India, when you look, okay, it is completely depends upon the controller's decision only. So it is a discretion of the controller whether to grant any compulsory license or else to deny that particular compulsory license. So he will look into a few grounds whether these measures are taken by a patentee or else any licensee, okay, to use fully of that particular invention or not is one of the important ground. And also the controller will look into the ability of the applicant to work on that particular inventions or else the capacity of that applicant with related to the manufacturing capabilities as well. And also the most important thing is that the applicant must make an efforts actually to obtain that license, voluntary license. Before going for a compulsory license, the applicant should approach that a person who is having a patent. So to that particular patentee, he need to write to obtain any license agreement from him. So there should be based on the reasonable terms. So how long? At least for the 6 months he need to try for that, okay, until without trying for this voluntary license thing, and directly if he would like to go for a compulsory license, so the controller may not grant any compulsory license. And there is a best example in India with related to one pharmaceutical product. So with this related with the BDR pharmaceuticals, they approached actually to the controller for the issuing of the compulsory license. But the important thing they missed is that, okay, they couldn't able to approach the patentee for any voluntary license actually. So they didn't even negotiated with him before applying for the compulsory license. So based on that ground, the compulsory license have not granted for that BDR pharmaceuticals. So there should be a effort should be made to obtain a compulsory license from the patentee is the very important thing. And also the controller will look into a few important aspects with related to the capacity of that applicant, whether he can make that product or not. Why these are important? Because when you look into the grounds for the obtaining a compulsory license, these are the grounds mainly with related to the availability of the product to the people, and also the price of that particular product, and also the manufacturing of that particular product should be in that particular territory or not, right? So when you are talking about the price of that particular product or else the availability of that particular product, so the interested party or else the interested person should be capable of making that product and bringing that product to the market in an affordable price, right? So that is the reason why controller looks always the ability of that particular applicant and also the capacity of that applicant with related to issuing of compulsory license in India. So what are the terms and conditions to issue a compulsory license? So there are few terms and conditions with related to the compulsory license. It doesn't mean that when someone is approaching for compulsory license, any interested party, and also if all the grounds have been satisfied, so the controller will not give simply for that compulsory license for any particular time period. So there are few grounds and conditions for the compulsory license, and also these may be little bit a disadvantage sort of thing with related to voluntary licensing agreements. So first and foremost thing is that royalty and other remuneration should be reasonable, but what is the royalty and also what can be the remuneration should be paid? The act is not very clear about that. And also reasonable profit to the applicant should be there. And also the availability of the product to the public at a reasonable affordable price is also should be maintained. And also this license is not an exclusive license to that person. For example, if any pharmaceutical product, any pharmaceutical company obtained a patent, right? So it doesn't mean that he's having an exclusive license on that. So even though the patentee can give a license to A, B, C, let's take it, okay, Innovatis issued a compulsory license to ABC company. So now he can give a normal license, voluntary license to Cipla, Dr. Reddy's, etc. So it doesn't mean that once you get a compulsory license, it is not a non-exclusive license. And also you cannot assign that compulsory license to anyone else. It is only restricted to that person who obtained that compulsory license in India. So he can only use that particular license with related to manufacturing of that product, or with related to the process, or with related to the diagnostic tools, etc. Right. So this is not assignable to anyone else, and it is not exclusive license to that person. So these are very important things with related to the terms and conditions of compulsory license. And also this makes the difference between the compulsory license and also with related to the voluntary license. So there are different mechanisms actually. So when someone would like to get an license agreement with related to pharmaceutical product or etc., so they need to approach for any voluntary licensing, or else they can go for the cross licensing, or else based on the grounds that are mentioned under section 84 of Indian Patent Act, they can approach for compulsory license after trying for a certain reasonable time period. So as I mentioned, there is one of the good and best example with related to the compulsory license in India, which is related with the NATCO versus Bayer. So here actually, when you look, the price of this particular product is very much high. So this is with related to the treatment of cancer. So the price is 2.8 lakhs for 1 month therapy by the Bayer Corporation actually. But the price that NATCO quoted for to get the compulsory license is that, okay, they can sell for the 8,800 rupees only for the therapy for 1 month. So you can see that, okay, there is a drastic change with related to the cut down of affordability of the price. And also like the Bayer got the royalty of 6% from the net sales of that medicines from the NATCO pharmaceuticals. Now we can think that by looking this, there is so much of change with related to the price of the product. But the thing we need to keep in our mind is that to achieve this particular product, or else to bring this particular product to the market, so there are n number of research and developments have been happened. Even we saw in our previous slides as well, in the first presentation as well. So 1 in 10,000 molecules only can be successful, and then it will come into the market, right? So there is a lot of investment with related to the research and development. So there will be few products which can fail in the last stages of clinical trials as well. So that they need to go for the clinical trials as well. So the amount will be incorporated here to get a product into the market, or else to MRP that particular product here, which includes even the research and development that they have invested to attain, or else to bring that particular product into the market. Now, when you look into the NATCO pharmaceuticals, obviously the answer is no, that okay, they didn't even invested a single 1 rupee with related to the research and development here. And just by looking into that patented product, and also as we know that, okay, when you apply for any patent applications, the first and foremost thing is that you need to disclose each and everything with related to your patent. So when you look the claims of your patent applications, a person skilled in that particular art can easily understand that, okay, how this product, or else how this process is made. So how this patented technology is made, okay, how this the product with related to the Bayer technology could able to come to the market. So by looking into that patent document, the NATCO pharmaceuticals can easily make trials, 1-2 trials mostly, and they can come to the easily, they can get back to this this product with related to the Bayer. So hence there is no investment with related to research and development and with related to regulatory approvals, etc. Right? So they just need to look into that, and then they need to replicate and they need to produce that product. Then hence they can market it for 8,800 rupees, even though it will be very much profitable for the NATCO pharmaceuticals as well. So this is one of the important thing that we need to look when we are going for the compulsory license. One with related to the research and development and also the innovations and the amount of funds that they have invested in research and development to get back that product. Next one is that, okay, the human health, and also this, how could this innovations can cater to these humans, okay, whether it is affordable to the public or not. So this both should be balanced actually with related to intellectual property rights, and this is very challenging mostly with pharmaceutical products. So one can easily argue that the bear is, it can be easily argued that, okay, the amount of investments that they have kept for research and development is this X amount. And also the NATCO can say that, okay, so we can bring that product into the market with reasonably affordable price, and also it will be available to public. So here NATCO successfully could able to get the compulsory license in India, and till date this is the only one compulsory license in India, and there are no compulsory licenses granted in India after this NATCO versus Bayer. So there are a few companies, as I mentioned already, BDR Pharmaceuticals has approached for compulsory license, but they couldn't able to establish that grounds on which they would like to get this compulsory license actually under Section 84 of Indian Patent Act. And there is a recent example with related to compulsory license, and also that is also mainly with related to NATCO Pharmaceuticals. So NATCO Pharmaceuticals actually approached controller of patents for compulsory license with related to a product of a company, Eli Lilly actually. So they tried actually for the compulsory license. They tried first for the voluntary license. They approached it, but Eli Lilly didn't responded for that license agreement. So what they did is like they applied for the compulsory license actually with related to COVID related product from the Eli Lilly. So after waiting for few months, okay, so when you look into the Patent Act, so Patent Act is not clear about, okay, how long you need to wait to get a compulsory license. Okay, this is one of the challenging aspect as well. So they applied an application, but they are still waiting for the compulsory license. This is taking so much of time, and then luckily the LA Lilly could able to sign a voluntary license agreement actually with NATCO Pharmaceuticals. So this will be a win-win situation for both. So by signing a voluntary agreement with NATCO Pharmaceuticals, LA Lilly could have negotiated even more royalty. So it all depends upon the agreement related terms and conditions actually. And the main difference between the voluntary license agreement and compulsory license agreement is that, and also the challenging issue is that compulsory license is without the consent of that patentee. So hence, so there will be a limited time period actually for the compulsory license, as someone is approaching the controller of patents for on any particular grounds to get a granting of that compulsory license. So once the grounds are fulfilled, so they can revoke the compulsory license also. But when you look into the voluntary license, so the terms and conditions in the voluntary license is completely different. And also this will be with willing or with the consent of that patentee, the license agreement will be signed. And also there are chances that they can share the know-how technologies as well with related to voluntary license, and also the royalty rates may be more, and also the time period for this license agreement will be long. So that is the one of the advantage with related to voluntary license when compared with that of compulsory licensing. So now when you look into the compulsory license in India or this compulsory license systems, so there are few advantages and also there are few disadvantages, or as you can say as challenges or issues with related to compulsory license actually. So the concept of compulsory license is echoing actually recently, because from last 2 years we can see with related to the COVID related vaccines and also waiving of intellectual property rights, etc. So along with that, compulsory license is also one of the subject matter that is echoing more. So what are the advantages with related to compulsory license is that, so it doesn't always, the patent, there is always something which related with compulsory license, which always says that, or else which always raises the red flag with related to monopolistic prices of any product actually. So you can say that, okay, there is some tooling mechanism to stop that monopolistic price if the prices are so much of high, and if any person is not able to afford that, a group of people couldn't able to afford that medicine, So you can say that, okay, there is a mechanism known as a compulsory license where any interested party can approach actually. So affordability of the public can be taken care with related to the process of compulsory license. And also this compulsory license will increase the competition with related to pharmaceuticals or else any with related to health related industries. So there is a balancing between the public health and also innovations when you look into compulsory license concept. So because as you see the grounds of the compulsory license where a public couldn't able to afford, or else the price of the particular product is very much more, availability of the product is not to particular category of the public, etc. Right? So with these related issues, so to cater mainly with related to developing countries or else underdeveloped nations. So this there isn't so much of advantage with related to compulsory license. Even the compulsory license product can the licensee can export the product to developing nations. So these are the few advantages of the compulsory license. At the same time, there are various challenging issues with related to compulsory license that I would like to highlight here. So first and foremost thing is that when you look into Patent Act, the relevant sections with related to compulsory license, so the remuneration and royalty should be reasonable. So what is that reasonable royalty and remunerations? So the calculations with at least under the Indian jurisdictions, so it is not clear about the royalty and remunerations. So it always depends upon the case-to-case basis. So when you look into the TRIPS agreement, it clearly says that, okay, it should be based on the case-to-case basis. That's fine. It depends upon the case-to-case basis. But how long it will take to calculate this royalty and remuneration process? Because when we are trying to invoke any compulsory license, there is something urgency to bring that product to the market in form of compulsory license agreement without the consent of a patent owner, right? So now the next important challenge is that availability to the public. So how can you term, or else what can be termed as an availability to the public? Whether a single person who couldn't able to afford that particular medicine can be termed as an issue with related to the affordability, or else availability of the public, which they couldn't able to reach to that single person. So how can we calculate that is also one of the challenging issues with related to compulsory license. So with related to the profitability and increasing in the royalty rates. So when you look into the only one case that I mentioned, that is the one case in India till date with related to compulsory license, as there is a royalty rate of 6% in year, actually in a year, it increases to 9%. So on what basis this affordability or is the increasing of the royalties rates can be made, or else are there any steps or else criteria or time frame that after 1 year there should be this much percentage royalty should be increased? So the act is silent about that, and these are the one of the challenging issues that we need to look. And also there are few other challenges with related to the capability or else availability of a licensee. So when any interested person is approaching, so he need to have that particular capacity to make that pharmaceutical product, right? So how can you calculate that? Okay, how can you look into that? Are there any inspection bodies that approach the facilities of any interested person who applied for licensing agreement, compulsory licensing agreement, to go and check that capability or as the ability whether they can produce or not? And are there any time frame that, okay, there should be investigations with related to yearly, they need to submit the working of that particular patented invention after attaining the compulsory licensing or not? So this is one of the challenging issue with related to compulsory license in India. So the most important challenge is that what is the timeline for getting a compulsory license after application? So are there any time frame that is mentioned under the Patent Act? So obviously the answer is no, that there is no particular time period that is mentioned to get a grant of compulsory license. So it may take, so based on the case to case basis, a long time to get a compulsory license. So the termination of compulsory license is also an interesting concept actually. So as per the Patent Act, so the compulsory licensing can be terminated at any point of time if that intended purpose is served by the patentee. So once the patentee serves that intended purpose where the compulsory license holder approached to get a patent license, the compulsory license can be terminated once the patentee approaches the controller of patents. So you cannot say that, okay, the compulsory license can be stayed for X number of years or as X number of months, etc. So it can be terminated at any point of time once the patentee approaches the controller to terminate that compulsory license based on the grounds that, okay, he could able to produce that patented product for affordable prices, etc. Now, next, one more important thing is that, okay, no price control mechanism actually with related to the compulsory, even though the compulsory license is achieved. So there is no change in the price of that patentee. So the first patent, for example, when you look into NATCO versus Bayer, so the Bayer Corporation didn't reduce even single rupee of its patented product. So it marketed with that only. So 2 lakh rupees. So it started marketing its product with the same price, but there is no price control mechanism on that. Only advantage is that there is one more player in the market, that is NATCO Pharmaceuticals, so which can start marketing and also which can start giving this particular patented product for affordable price, 8,000 rupees. So there is no price control mechanism is seen here. It is just like any interested parties can approach and then they can start getting this compulsory license and then they can start manufacturing of that. So one more important challenge is that, so granting compulsory license may not give assurance for the transfer of knowledge actually. So know-how cannot be transferred, right? So once the compulsory license is signed, so it doesn't mean that, okay, the know-how and also the trade secret should be transferred to a licensee. So patent holder is holding that know-how still, and also the trade secrets may be there with him. So he won't transfer those things because without his consent, the agreement have been signed, and also based on the patented literature, they will start manufacturing that product. So hence there is no chance for transfer of knowledge, etc. But when you look into the voluntary license agreement, so there are chances that the transfer of knowledge will be there, know-how will be transferred to licensee as well. So there is win-win situations with related to that. So how can we address this particular issue with related to compulsory license is one of the challenging issue. So as I mentioned already, so compulsory license term is always limited to the purpose. So it is authorized. So once the purpose is served, the compulsory license can be terminated. And if the if the purpose is not served, this compulsory license can be even continued also by the application of from the licensee actually. So he can even request for extension of compulsory license as well. So this also can happen. So there should be always a mechanism with related to increasing the cross licensing or as the voluntary license agreements between the parties. So as one of the alternative mechanism that we need to look with related to compulsory license. So it doesn't mean that always compulsory license will be the solution to obtain the technology or as to obtain the products or make the products to accessible to the public, etc. Right? So there should be an interference from the governmental institutions also with related to the price fixations. As we know that, okay, with the same example, there is no monitoring on the price with related to that Bayer's pharmaceutical product as well. So governmental interference should be there with related, or as a policy related changes should be made with related to price fixations or as price control mechanisms, at least with related to national securities or with related to the epidemic issues. So with related to COVID-19 issues. So when you look into this, okay, there should be a mechanism with related to altering the price mechanism. So it always should not be there that, okay, n amount can be fixed by the applicant, etc. So there should be always an interference with related to governmental bodies as well. So these are the various different challenges with related to the compulsory license in India, and then how we will address this thing is a challenging issue. And with related to India, only we can say one compulsory license agreement, and hence there are no more compulsory license agreements. So we need to keep looking forward. So what are the changes or as modifications that can be done with related to Indian jurisdictions? And when you look into the international developments with related to compulsory license, one best example that we can take is with related to Brazil. So Brazil had made an amendment and they came up with the two-step process with related to the compulsory license. So whether this two-step process can be adopted in India, or else can it be advantageous in India, or else it will be a disadvantage to the patent holders or not, is one of the important things that we need to look. So what is this two-step process is that, so once there is any national emergency exists in Brazil, so they need to list down the products, the process, or else the diagnostic tools, etc., to address that issue. So within 30 days, they need to make a list of all the patents that are available, all the products that are available to address that issues, right? So there is a 30-minute time frame actually. So after 30-minute time frame, so only the compulsory license will be granted to the products which are listed in that 30 days time period. So here what happens is like the process will be a little bit fast with related to compulsory license. And one more thing that the Brazilian government is proposing is that after signing the compulsory license, that know-how also should be shared, and also the regulatory approvals also should be shared with the compulsory license holder, or else they can nullify the patent. So this is one of the important challenging issue again with related to compulsory license if this comes into force. So again, like whether this will encourage the innovators to file the patent applications in Brazil or not is the one more important challenging issue. Hence, I would like to end here, and we are open for the questions with related to compulsory license in Indian scenario mostly. That's all from my talk. Thank you.